Hello, I'm Dan Marr, and I'm going to be talking in this vlog about revocable trusts in New Hampshire and the issues that I've seen in litigation in regards to these, or disputes in regards to these. Revocable trusts are a wonderful estate planning document. They avoid probate, where you take your assets and you put them into a revocable trust, and during your lifetime you can make all the decisions you need to, as long as you have the capacity to do so. And then upon death, instead of the property going through your will and through a probate court process, it avoids the probate process and it goes to your intended beneficiaries or to your trustee to take care of the beneficiaries as you see fit. Wonderful idea. Three things that happen that I've seen when people don't go to a lawyer and try to deal with this from the internet, pulling off the documents. One is the issue of not having clarity in the document itself as to the successor trustee, what they're supposed to do. Are they supposed to be taking care of the beneficiaries for a period of time? Is there a certain age upon which they're going to make distributions to them? Are they supposed to liquidate the assets immediately upon when they turn 18 and distribute to them? All of those issues you need to deal with. If they have a drug problem, if you have concerns about their marriage relationship, all those things, deal with them then in the trust and give guidance to the trustee. So that's an issue of not telling the successor trustees right in the trust document what to do. Another issue is identifying who your beneficiaries are. Strangely enough, I've had a variety of documents where people think they know who the beneficiaries are. They're thinking it's their kids or they think it's their spouse, but they don't spell it out in the trust document. They got to put it in the trust document or a schedule of beneficiaries. They have to make that clarity known to others in writing as to who the beneficiaries are, or when you pass on, well, you might be you're the obviously beneficiary until you die. Who gets it afterwards? That's a big question. You can have a failed trust because you haven't done that. The third issue that you have that's a very important issue too is actually funding the trust. We have situations where people think that a trust is a very good idea. They create it, but then they don't put the bank accounts into the trust. They don't put their investment accounts into their trust. If they generally don't have your real estate, your life insurance into the trust, or usually have your spouse as the first choice. But thinking about that through, maybe it's appropriate to have your life insurance in the trust. Talk to your estate planning attorney and deal with that. Certainly your properties, real estate, if you want your house in the trust, you have to deed it into the trust. So you have to fund the trust. It's called the trust corpus. You have to take those steps. So all of those things, lack of clarity as to what the successor beneficiary is supposed to, or trustee is supposed to do, defining your beneficiaries in the trust documents, and funding the trust are all critical issues that you have to deal with, and that's why you should go to an estate planning attorney for this.